no less. All of the territory in question falls within the territories covered by the European Convention. No state can purport to subcontract out responsibilities to a non-state entity with regard to the territory of another state and then claim to be free of the constraints of the Convention. There can be no legal black holes in the lands of the European Convention on Human Rights. It does not need me to tell this Court that jurisdiction has a specific meaning under Article 1 of the Convention, building upon but moving a notch above traditional international law principles of state responsibility. General international law has developed principles of state responsibility, exemplified in the Nicaragua and Bosnian genocide cases before the ICJ. However, it is now accepted that specific human rights regimes, complete with binding mechanisms, may add value to these principles. This has been shown in the Tadic case before the ICTY and in established and respected and consistent judgments of this Court, including Loizidou, Issa, and most recently Al-Skaini. Incidentally, it has affected not just the special definition given to jurisdiction as a term of art in Article 1, but also the position with regard to the effect on reservations to specific human rights treaties. The door to reverse this progressive development has surely closed. The Cyprus situation is analogous to Nagorno-Karabakh, with one difference. In the former case, Turkey was transparent about its presence in northern Cyprus. In this case, Armenia seeks to draw a veil of secrecy over what is widely known. The NKR cannot function without Armenia's existential backing, which is military, economic, political, and financial. The two are extraordinarily intertwined. What is even more blatant here is that the Latian area, where the applicants live and where their property was and is situated, lies between the NKR and Armenia proper. Armenia's arguments before this Court is that it is the NKR which effectively controls the relevant area. We argue that Armenia, directly or indirectly through its subordinate local administration, the NKR, is in such effective control for the purposes of Article 1. This falls squarely within the paradigm established by this Court in Loizidou, Cyprus against Turkey, Ilashku and Al-Skaini. But what is the legal test applied by the Court? In Al-Skaini, now the leading case on extraterritorial jurisdiction, the Court emphasised that such jurisdiction and responsibility would occur where a state, through its agents, exercises control and authority. Further and critically, the Court underlines that Article 1 would apply where a contracting state exercised effective control of an area outside its national territory. Its obligations under the Convention derives from the fact of such control, whether exercised directly through their own armed forces or through a subordinate local administration. It is not necessary to demonstrate detailed control over the policies and actions of this subordinate local administration. It is a question of fact whether a contracting state exercises effective control over an area outside its own territory. In determining this, the Court has said it will have primary reference to the strength of the state's military presence and activities in the area, while other indicators may also be relevant, such as the military, economic and political support for the local subordinate administration. The Court, therefore, has to examine the facts of the case in order to determine what is the reality and whether Armenia is in reality pulling the strings. I do not propose to repeat all of our evidence presented over the years, up to and including December 2013. I will merely point to some of the essential facts grouped in terms of the court's own categories. Military presence, something which I see is simply not denied by the respondent state. The series of proposals from the Minsk peace process in the late 1990s all called for the withdrawal of the armed forces of Armenia to within the borders of the Republic of Armenia. Various NGO reports have demonstrated the extensive presence of conscript forces in the NKR, something which is now admitted, and the high degree of integration between the forces of Armenia and Nagorno-Karabakh in the supply of weaponry. This court has found that the Republic of Armenian forces serve in the occupied territories, and indeed that the detention, questioning and prosecution of such soldiers took place in such territories, in the Haratunian and Zalyan cases. A series of serious internal incidents involving the deaths of Republic of Armenian forces located in the occupied Khojavand district of Azerbaijan was noted in the Armenian media in 2010. Armenian soldiers serving in the NKR have voted in Republic of Armenian elections. In April 2012, a resolution of the European Parliament was adopted within the context of a proposed EU-Armenia Association Agreement. In that resolution, it was underlined that deeply concerning reports exist of illegal activities exercised by Armenian troops in the occupied Azerbaijani territories. There was a call for the withdrawal of Armenian forces from occupied territories surrounding Nagorno-Karabakh. This is supported by many authoritative statements. The US Department of State's country reports on human rights for both 2011 and 2012 underlined that the NKR and the surrounding territories, including Lachin, were controlled by ethnic Armenian separatists with Armenia's support. Further, in 2012, it was reported that an Armenian soldier had been shot dead by a colleague, and this had been investigated by the Armenian Ministry of Defence under the Armenian Criminal Code. Evidence not only of the effective control of Armenia, but of the involvement of officials and agents of Armenia, thus complying with the requirements of both forms of responsibility in Alskani. The extensive ties between Armenia and the NKR continue to be evidenced and progressed by continuing high-level visits. The political support given by Armenia to the NKR is evidenced by statements made in 2013 by the President of Armenia, in which it was stated clearly that Armenia acts as the guarantor of the safety of the people of Nagorno-Karabakh. The President of Armenia, the former President of Armenia, both held offices in the military and the political structures of the NKR before moving into Armenia proper. The economic links between Armenia and the NKR are formidable. The All-Armenian Fund was founded by Armenia and is controlled by it. The President of the Board of Trustees is the President of Armenia. It funds an overwhelming number of activities in the NKR, ranging from the construction of hospitals, electricity substations, highways, bridges and water supply networks. It is clear beyond doubt that Armenia exercises a degree of real, effective control in reality over the NKR and surrounding occupied territories, including Lachin, that prevents it from denying its responsibility under Article 1. The applicants are therefore entitled to the protection of the Convention and of this Court. Thank you.
Thank you, Professor Shaw. I give the floor to Mr. Lansky.
Mr. President, esteemed members of this Court, let me deepen and go more intensively to the topic of effective remedy, which has been addressed by Mr. Müller.